Yes, I salute you all. Thanks for listening and thanks for watching. So basically today we are under the law of negligence, basically. But today we are going to look at strict liability in Torts law, in Torts law 2, or in the law of negligence, basically. And there is a famous case under strict liability, of which that's the case that we are going to look at under strict liability, basically. That's the case of Rylands versus Fletcher. As a scholar of the law of negligence, or most on the topic of strict liability, this case must be on your fingertips so that it is the one that helps you to argue out strict liability in any angle it comes in. You get the facts of that case actually. It comes in whereby John Rylands constructed a reservoir on the land that was renting to supply water to his steam-powered textile mill. And also, Fletcher was also operating mines in the area, and both were renting the land. They are renting land on the same person. They were neighbors from Lord Wilton, basically. So, as a result, John Rylands employed independent contractors and engineers to the work of building a reservoir, which was completed in December 1860, basically. So this reservoir that was completed in 1860, the lands were in Lancashire and known. Actually, the reservoir was next to the mines of Fletcher. So as a result, and there's something that happened that various series interconnected in the shafts of the tunnel. As these people were digging, they came to realize that they were disused mine shafts in the soil across, basically, but they didn't fill it with any mud or soil. Basically, they left them. There was no attempt made to seal them. They left them as they found them. So in fact, the shafts led via the series of interconnected shafts and tunnels into Fletcher's mines, and the water from the mill reservoir flooded into Fletcher's on the 11th December, still in 1860, basically, and just days after even the completion of the reservoir. So as a result, Fletcher sued Rylands to recover damages. And the issue that was there before court was whether the doctrine of strict liability could be applied to inherently dangerous activities in the same way as it was applied in nuisance and cattle trespass, basically, as we shall see in front there in our next video. So that was the issue. So basically, Fletcher was relying on the doctrine of strict liability, whereby at the end of the day, court ruled in the favor of Fletcher and ordered Rylands to pay for all the property damage to the mine. The court agreed that the Rylands had a duty in maintaining the reservoir and of being liable for all the harm caused with the broad aspect of liability caused by the independent contractors that he had acquired. So actually, in this case, there is a speech whereby the justice that was there, Justice Colin Blackburn, he lamented something that was so nice. Basically, he said that we think that the rule in law is that a person who for his own purposes brings on his lands and collects and keeps anything likely to do mischief, if it escapes, must keep it at his own peril. His own peril, and if it does not so, is prima facie answerable for all damages, which is the natural consequence of its escape. That's what he said under that case of Rylands versus Fletcher. So here he highlighted the requirements. Under that statement, we got to know the elements of strict liability, basically. One of it, that the defendant brought something onto his land. You get, the defendant brought something onto his land, basically. In this essence, is that you must have brought something onto your land. In this essence, for example, you have the case of David Dibia versus Uganda Electricity Board. where the Uganda Electricity Board left hanging live dangerous wires that the plaintiff was shocked on stepping on them. It was said that it amounted to bringing something onto the land, basically. Bringing something onto the land. You get? That is the case. The other one is that the defendant made a non-natural use of the land. Non-natural use of the land. What do I mean by something that is a non-natural use of the land? Is that you have made something that is man-made or temporary. For example, in the case of Rylands, the other one constructed the reservoir, as we have seen. You get? For example, here we have the case of Mason versus Levy Auto Parts Limited. Mason versus Levy Auto Parts Limited. Under this case, the defendant stored flammable material in their lands, and it caught fire, of which the fire was flaming. They went to the neighboring parts. So it was said that he was liable for the materials that he had brought, because there was a non-natural use, basically. Not that in mind. There was a non-natural use. Another element that we can see that the thing was something that is likely to do mischief if it escapes. For example, in the case of Mason that I've talked about, it was a flammable composite. So if fire starts, so if it escapes, it can cause mischief. Basically, in the case of Rylands versus Fletcher, it was said that if the water escaped, it would cause a mischief to the mines of Fletcher. You get? So basically, note that in mind. There's also whereby the thing did not escape and cause, the thing did escape and caused what? And the thing did escape and caused the damage. Where there is no escape, the strict liability is not there. The thing must have escape. For example, you have the case of Reed versus Leon. Reed, R-E-A-D. Reed versus Leon. Under this case, the question was escape, of which they held that the defendant wasn't liable. Reason being that there was no escape. You get? The respondents were under an agreement. In this essence, it was an explosion at the shell. You get? At the shell. The Court of Appeal heard that defendants were not liable. You are not reliable. Reason being that the rule under Rylands versus Fletcher, first of all, it acts on damage to property, not on personal injuries. That is one of it. You get? Could only be recovered on personal property. In the case of Reed versus Leon, but not personal injuries, basically. So another one that is key, the foreseeability of damage. The one that has acted has brought something on the land. You must foresee the damage of that thing once it escapes. Once there is no foreseeability, there is no strict liability. We have the case of Cambridge Water Works versus Eastern Countries Leather. Eastern Countries Leather. Under this case, the element of foreseeability wasn't there. You get? This was a company that had a certain substance, which this certain substance was falling on the floor. You get? So it fell on the land, took 9 months to reach the borehole, the water of the plaintiff, which the distance was, the company was like 1.3 miles. And it took 9 months, basically. It took 9 months to reach the waters. So the court held that foreseeability of damage is relevant. But in this case, the defendant couldn't foresee that the chemical solvent could reach the water. Because, for example, it was falling on the floor, but it was moving at a slow pace underground. You get? So the element of foreseeability was lacking in that essence, basically for the defendant to be liable under strict what? Liability, or to be liable following the rule in Rylands versus Fletcher. At the end of the day, he was not liable. So that is strict liability and its elements. However, you have the defenses under strict liability. You have defenses under strict liability. One of the defense is consent. You get? Where there is consent, someone cannot be. It is a defense, basically. Consent. We have the case of car stayers Castellers versus Taylor. Under the case of Castellers versus Taylor, the court held that once someone brings something onto his land with the consent of the defendant, at the end of the day, he cannot be liable because there was consent at the very first for him to bring that particular thing that he placed on his or her land. You get? Whereby, even there is also where they say that where the thing that was brought on the land, the plaintiff, the defendant is benefiting. At the end of the day, his benefit means that he has consented. The consent will be implied. You get? Where the plaintiff occupies premises which are already has an hazard, he will not be presumed to have actually. There is where they say that where the plaintiff occupies areas that there is risky, doesn't mean that he has consented in that regards. You get? So at the very fact, the case of Castellers brings out that element. Under consent, where you, for example, if you know very well that your neighbor has what and what, you see that there is risk, but you decide to be the neighbor. Once it escapes, you cannot say that you knew very well and decided to extend here. No, it is not a defense there in that essence. Whereby strict liability, you are strictly liable. So basically, we have another defense which is act of God. Act of God, we have the case of Nicholas versus Marsland. Nicholas, whereby in this essence, where something that is comes by an act of God, it can be as a defense. You get? Whereby in that case of Nicholas, the defendant for many years had been in possession of some artificial ornament, lakes formed by damming up a natural stream. In this essence, there was an extraordinary of rain that broke the artificial embankment and washed away the four bridges, basically. So court held that that was an act of God. But however, in the case of Greenock Corporation versus there's a case of Caledonian. The court diverted that an act of God, it is a defense once there is no an extraordinary. Once there is no that actually that extraordinary making or that extraordinary. For example, in this case of Greenock, the defendant I may assume constructed a concrete ponding pool for children. So it rained very well and distracted it, leading that the people that were on the lower valley were engineered. So the court held that these people could not embark on the defense of an act of God because they had made a supplement of an extraordinary. They had tempered simply with the kind of nature. You get? An act of God can act once it comes plain and you didn't expect. But if you construct something and you know very well, if rain comes, the thing may fall on the people that are down. So it may be actually at the end of the day, you are liable. You can't say that rain and no, you are liable. That is an act of what? An act of God. The other difference, you have the act of the act of or the default of the plaintiff. So it is the plaintiff that I can call it contributory negligence, the act of the plaintiff himself. In this essence, we have the case of Eastern SA Telegram Company versus Cape Town Tramways Companies Limited. Under this case, the defendant stored and used electricity for working in their tram cars. It escaped and interfered with the sending of messages by the plaintiffs through the submarines, basically cables. The escape wouldn't have caused interruption of telegramic communication generally, but the plaintiff was unusually sensitive to current, to that issue. So what court held? Court held that a man cannot increase the liabilities of his neighbor by applying his own property to special uses, whether for business or for pleasure. You cannot increase your liabilities for your neighbor simply because for you your property is applicable to special properties special uses. Basically, realize I can give an example that I can give an example whereby you have done a particular act, and in this instance, what we are looking at, or what we are trying to imply is that your neighbor is actually is increasing the liability. Basically, is increasing the liability. The reason being, I say that, you know what, you smoke, I'm a claustrophobic, I'm what and what, just because of your mere what? Your mere pleasure. So in this essence, the act of the defendant can be as well as what? Contributory what? Negligence in this essence. Basically not that in what? In mind. Another defense that we can talk about, we have the defense of an act of a third party. Where a third party makes a particular act, a person cannot be what? Liable in this essence. You have the case of Rylands versus Lothanian. Rylands versus Lothanian. Here the court held that the onus is on the defendant to prove that the accident was the result of the act of the stranger. Once the stranger makes, however much I'm the owner of the land, but the act that has caused damage, it is done by the person who is a stranger to me, or who is a third party of which it is not me. So you cannot sue me because of the act of a third what? A third party. So basically note that in mind and bear that in what? In mind. Then we have statutory, another defense, which is statutory authority. Statutory authority, this I can give an example of these people that construct roads, the people that make pipelines of water, among others. Realize that they may be constructing a road and they knock a pipe. The pipe splashes water into your house, what and what. So those people are not liable because they are there by the mandate of the statute. It is their statutory obligation to construct roads. It is their statutory obligation to make sure that water reaches in any part of the country. You get, for example, in the case of Sharing Cross Electricity Company versus Hydraulic Power Company. In this instance, the company was under a statutory authority to supply water for industrial use and laymen's. So amid court held that the construction of that in question, the company had the obligation to maintain a supply of water. In this essence, because amidst the damage, the plaintiff is what? The plaintiff is lanes as they were in construction. So, however, they were exempted under statutory what? Authority. So basically, that's what I can give about strict liability. As now next video, we shall look at liability for fire escape and liability for dangerous animals. But other than that, thank you for listening and thank you for watching. Stay blessed and stay on. Ask questions where I feel necessary. And I wish you good luck. Thank you very much.